this is Amisha. Today we will discuss the case of Eastern Book Company versus D.B.Modak. In this case, uh, plaintiff claimed copyright in copy-edited judgments of Supreme Court. The main issue involved in this case is whether a copyright exists in derivative work or not. Um, while discussing with the main issue, Supreme Court discussed Section 13 of the Copyright Act, which states that the copyright protection is given to those literary works that are original in nature. Supreme Court also discussed various doctrines, one of which is doctrine of sweat of brow. It states that the creation of work resulted from little bit of skill, labor, capital are sufficient for a copyright in derivative work of an author. Compilation produced from original work is more than simply a rearranged copyright of original, which often refers to as skill, judgment, or labor capital. Copyright has nothing to do with originality or literary merit. Supreme Court then proceeded to discuss another test, that is minimum degree of creativity, laid down in Flist publication versus rural telephone services. In it is a U.S. Supreme Court U.S. Supreme Court judgment. It was held by the court that sine qua non of copyright is originality, and only those work can be protected under copyright that work are original to the author, and it should be independently created by author and should not be copied. It should possess a minimum level of creativity. It was also stated in this judgment that selection and arrangement independently of the compiler must attain minimum degree of creativity so that the work is original and it's protected by copyright. In this judgment, U.S. Supreme Court also criticized doctrine of sweat of brow. It stated that in the doctrine of sweat of brow, protection is given beyond the selection and arrangement. It also stated that the doctrine of sweat of brow violates the fundamental axiom of copyright, and it gives copyright to even the facts and ideas of the work. It also stated that it doctrine of sweat of brow creates monopoly in public domain materials without necessary justification of protecting and encouraging the creation of writing by authors. It also stated um, in the judgment that the primary basis of copyright is not to reward labor of author but to promote progress of science is useful art. In the judgment of Eastern Book Company versus D.B.Modak, Supreme Court further proceeded to discuss a mid-level test laid down by Supreme Court of Canada in CCH Canada Canadian Limited versus Law Society of Upper Canada. It was laid down in this code that for a work to be original, for it to be protected under copyright, work should originate from author, should not be copied, and should be product of author's exercise of skill and judgment. Exercise of skill and judgment required to produce work should not be trivial, and it is that is characterized as purely mechanical exercise. In this judgment, doctrine of sweat of brow was criticized, and it was stated that the doctrine of sweat of brow, uh, in doctrine of sweat of brow, the standard of originality is too low and shift far in the favor of owner's right and fails to protect the public interest. Moreover, the doctrine of minimum level of creativity was also criticized. It was stated that creative that doctrine of in this creativity standard of originality is too high. It implied that it was also stated that the this doctrine implies novel or non-obvious concept associate that is only associated with patent law and is not and should not be associated with copyrights. Further, in the further in the court of in CCH Canada case, it was held that copyright in compilations, author's work should be result of his skill and judgment, which should not be creative in sense that it is novel or non-obvious, but at the same time it should not be a product of mere labor and capital. More So Supreme Court in case of Eastern Book Company versus D.B.Modak followed the test laid down in CCH Canada case, that is mid level test. And Supreme Court uh, and Supreme Court uh, uh, made a decision that defendant will not be able to uh, use uh, those inputs that were those inputs that were you that were laid that were the result of plaintiff's skill and judgment. For example, um, a defendant shall not use paragraphs made by appellants in copy edited judgments, internal references, editorial judgment regarding opinion expressed by judges.